Ladies and gentlemen, I welcome all to my channel. Today, let us see two important maxims, legal maxims. One is called caveat emptor, and another is called doctrine of uberrime fide, or doctrine of utmost good faith. Uh, Caveat emptor, the legal maxim caveat emptor means let the buyer beware. So, as per the general rule is that the let the buyer beware. The purchaser who wanted to purchase a thing should take all reasonable steps, and he cannot simply say that I have without knowing these things I have purchased these things. So basic elements. Supposing your person is you are purchasing a property, it is a duty of the buyer to verify the title properly, and he have to apply encumbrance certificate. Through that, he has to verify the title of the seller. So when all the purchasers should take all precautions, and he should be beware of all the purchasers should all the buyer should be beware of all the times, all the things about the material things which is reasonable, which a person can reasonably find out easily. So the law says a caveat emptor. Purchaser should be beware of all the things, so he cannot later say that I do not know this fact and this contract is not valid. Like that, he cannot question. So opposite to this principle, let the buyer be beware, caveat emptor. One more maxim is called doctrine of uberrime fide. It is also called doctrine of utmost good faith. In some contracts, some type of contracts, the law stipulates that there must be doctrine of utmost good faith with all the parties dealing with the contract. Especially in insurance contract, this doctrine of utmost good faith is one of the important thing, and the caveat emptor principle will not apply to all insurance contracts. So the utmost good faith must be there in the contract of insurance. Supposing a person has some cancer or any heart problem, and he suppresses that fact to the insurance company and makes a contract, and subsequently he makes a he he was hospitalized for the treatment to heart problem or any cancer, and makes a claim to the insurance company. The insurance company will reject the claim, saying that you have not disclosed your previous diseases. Say you have suppressed your cancer, or you suppressed your heart disease. So the law expects in the law of contract, in law of insurance, the law expects that there must be utmost good faith in entering into this contract. So whenever insurance contract is made, you will have to disclose all the material facts which is known to you. Supposing you do not know that you have any heart attack, heart problem, then in that case it is not a problem. Supposing you have a problem, heart disease or any cancer or any other problem, and you suppress the fact to the insurance company and enter the contract, then subsequently if you make a claim, the insurance company may reject your claim, saying that you have suppressed these things, and the contract itself is invalid on the ground that you have it is a contract made in violation of the doctrine of utmost good faith. So whenever you go for an insurance contract, it is always advisable that you should disclose all the facts which is known to you. If some facts is you need not disclose, the law does not expect you to disclose all the facts which is not known to you. If you have a sugar problem, you have to say, yes, I have sugar problem. If you have a heart problem or any other peripheral surgery, you have to mention those things. Suppose you have done a surgery and you have suppressed that, in a particular column, you mentioned that I have not made any surgery, and later point of time, it was known to the insurance company that you have undergone a surgery, it was suppressed in this Indian contractor, in the insurance contract. Then underground also, the insurance company may reject your claim, and on the ground that you have not followed the principle of doctrine of utmost good faith. So, caveat emptor is a general rule. Let the buyer be viewer. It will apply to all contracts. But in some contract like insurance, the doctrine of ubirime fidi or a doctrine of utmost good faith will apply. In such cases, the buyer has to, the parties to the contract should observe the doctrine of utmost good faith. Otherwise, the contract can be said to be held to be declared to be invalid on violation of this doctrine. Ladies and gentlemen, I have two channels, Raziaq Sattam Arivom and Raziaq Lativ. You may watch my videos and enrich your knowledge. The students may give your comments and also share this video to your friends, to whom it will be really helpful. Thank you. Goodbye.